The way I understand it, the the assessor provides a number of, I have the code here. The reason I'm bringing this up is because we've been asked to submit our opinion relative to how the count was accomplished. Sam, do you remember what section that was? 174? Yeah,
Oh, that's good.
yes, yes, so make a copy. Oh, 174-9H.
HG.
174-9H.
Line G.
Yep. Which reads, the total cumulative number of units approved under this section by the Zoning Board of Appeals since January 1998 shall at no time exceed 7% of the total number of one-family houses in Southborough at the beginning of the year in which the application is filed, based on the assessor's records. So the primary number is provided by the assessors. Then it says, residences containing apartments shall be counted as one-family houses for the purpose of this subsection. So the building inspector was asked his opinion. This is a draft letter. Let's just send it down. I hope I get this right. The building inspector was asked his opinion on how the count was arrived at, and I believe, Sam, you sat with the building inspector. I'm going to ask you to speak in a minute. So you can fill in the gaps or make the corrections as to my understanding of it. So the building inspector then asked my opinion, and I felt that it was important that my opinion wasn't as important as the opinion of the 5 members on the planning board. So that's why I have a draft letter here that I want the board to look at. You don't have to, I'd like to have you read it and either agree or disagree with it tonight, and if there's agreement, I'll sign it, or if there's some changes that we want to make, so on. But basically, what my recommended response to the building inspector is that his understanding is the same as the town planner's calculation, which was the initial calculation, which totals 11.6 units. And since this section is silent relative to rounding up or down, there are other sections in this code related to housing that does recommend or does say that you can round up or down. So because this is 11.6, it's been rounded up to 12. And I believe that's the number that the developer was given as far as the number of units that are available. So there's a table here that shows how the number was calculated. The second, the first column describes the property type. And remember that the the code here, section H1G, bases the number of one-family houses in Southborough at the beginning of the year. That number is listed as 2,837. And then there's a little bit of detail, which I thought was more than necessary, but we left it in there, as to how that number had changed most recently. And then the other ones talk about, then the next line talks about single-family lots, single-family houses, which is the term one-family houses that the code uses, that are on one lot. So how many single-family houses, how many do we have that have two single families on one lot? And this here says there's a total of 52 of those.
And does that equal 54 single-family homes?
Where'd you
I
get
mean,
the,
I'm sorry, 104 single-family homes? Or is it 52 lots with two single-family homes on the lots?
No.
Or is it
it's 52 single-family homes.
26 lots equaling 52? But both homes were counted as single-family?
Yes. Then it goes into these two-family and three-family type houses. There's 80 two-family houses, and there's 7 three-family houses. States here, residences containing apartments shall be counted as one-family houses for the purpose of this subsection. Building inspector states that a two-family or a three-family is essentially a residence containing apartments. So those are counted as one-family house. And those are the numbers. And then apartment buildings with over 3 units, there's 4 of those. So regardless of how many apartments are in there, those are only counted as a single-family house, 4 of them, totaling 2,980. And then the 7% gives you that 208.6. And the current that are permitted or constructed, and there is a difference between those that are permitted and constructed. There is a difference, but they added them together, which is 197, and that leaves you with the 11.6. I don't think there's any I haven't heard anybody disputing the number that the assessor gave, the numbers that the assessors have given us, but there is apparently a disagreement relative to how to count these different other types of buildings relative to the language in the code. When I went over it with the building inspector, and I read it myself, I agree that this number 11.6 is correct based on the information that was provided. So if there's different information, then that number may change. So before I ask the board, Sam, did you want to give the other side of the story?
Can I ask a question on the letter before we hear Sam's version?
Certainly, yeah.
It says 9/25/15, Bernie, based on data provided by assessors. I had seen that before. Then it was revised 12/28 after they added Fiddleneck. What does updated 105/16 relate to? Is something missing?
Is it this stuff?
I'm down here, I don't
Yeah,
know.
but this has got the date 105,
Up here?
yeah.
Okay.
So I don't know the answer to that. I'm
Well,
assuming
maybe I
that's-
would show it as a footnote,
Yeah.
This,
I don't
so it
think
relates.
just so you know, this table did not come from me. This was created by the town planner
Right.
before she left.
She gave it to us the Wednesday before she left. We discussed it at a
Right.
planning board meeting.
So we just cut and pasted it into this draft letter.
because that's when she had given it to us before, but when Fiddle Neck we found, I didn't know it, that Fiddle Neck had over 55 units in it. And I don't know what all this had to do with the tear downs and stuff.
They were notes that I didn't think were necessary, but I left them in, and if the
Well,
board wants to chop them out,
No,
that's
I'm
fine.
not saying chop, well, probably, but if I've had a hard time following what it just seemed like updated 105.
Yeah, are they
See assessor above or something, just so it's
included?
high.
Have those numbers been folded into
A
the
net of
numbers?
2, from what if I'm reading the chart right, a net of 2 there was 5 new, 3 got torn down, so there was a net of 2
Well,
new.
I can't tell from this whether the assessor is saying, and by the way, this has changed since the end of the year, or whether he's saying, and it's been included in the numbers. Because it shouldn't be included, because the numbers are supposed to be as of the first,
Well, if
first
it
of the
happened
year,
in
I
the
think.
if it happened in calendar year 15,
Yeah.
that 5 went up and 3 came down, then there would be a net, the number would change on January 1, 16 to show a net increase of 2.
Says here, the houses in Southborough at the beginning of the year in which the application is filed. When was the application filed?
Well, as
15,
over 55.
In 2015?
I think so.
Really?
I thought it was, I don't remember.
Well, we've had it before us, and it was not an over 55 when it got filed with us.
Oh,
I read about it in the newspaper. So, and I would say I read about it in 2016. So, I was like, when did that happen? I'm only serve on the planning board, why would I know what's going on? So, I mean, I literally read that in the paper.
So the application was filed in 2016?
Well, I don't know,
I think we saw it in 15.
but not as an over 55.
No, it was, yeah,
There was single family and duplexes at that point.
correct.
So it's 2016, Sam.
okay.
And this data is based on information that was provided on January 5th, 2016. So you and I talked about this before, but I didn't have the benefit of having this stuff in my hands or even in my head when we talk. So I'd like to have, you have an opportunity to speak to it.
Thank you. I'm Sam Stivers, 7 Presidential Drive, member of the advisory committee, but I'm speaking as a private citizen. I guess first, I don't actually have a dog in this hunt. I'm interested in zoning bylaw being applied accurately, and as I've spent a lot of time digging through that. And it seems to me that the language of the bylaw is abundantly clear. It says 1 family houses is the basis for the calculation. And I've heard town council and other attorneys say, and I'm not an attorney, by the way, on a number of occasions that courts pay careful attention to every word in the bylaw, and courts are not inclined to write new words in the bylaw to try to figure out what the intent of the drafters of the bylaw was. So if in fact the intent of the drafters of the bylaw had been to include 2 family, 3 family, 4 family, or whatever, that would have been extraordinarily easy to do by adding it to that list. For whatever reason, they chose not to add that. They said single family. So it seems to me that it is very correct to take the Assessor's Code 101, which is the 1 family, plus I think it was 106, which is the 2 single-family units on 1 lot. And by the way, I think there's some question about the accuracy of that number, because I know that at least one of those, I looked through the assessor's data, one of those is a pool house, for example, on a property that has a residence. So I'm not quite sure you count that as a single-family residence. But assuming those numbers are correct, and I don't dispute the assessor's numbers, you add the single family plus the 2 single families on 1 lot, and you use that as the basis for calculating the 7%. So I guess I'm puzzled by the building inspector's opinion, or the view that, oh yeah, we also ought to throw in 2 family, 3 family, 4 family, et cetera, and the base number for calculating the 7%. And I guess I commented at the zoning board hearing that it sure sounds to me, again, as a non-attorney, not a judge, that that's a great basis for an appeal if somebody disagrees with that. If you issue a permit based on a calculation that seems to have a pretty clear flaw in it, at least in my personal opinion. So that was the basis of my comment. And again, I'm not involved in this particular case before the ZBA, but I would think that it would be wise to be careful about issuing a permit based on a correct calculation as opposed to one that seems to be inconsistent with the way that bylaw is written. So that's my comment. Thanks.
Can I ask again for clarification why we're involved? The assessor determines the number of units. The case is a 40B before, it's not a 40B?
Is it?
Oh, okay, I thought it was gonna be 40B. Okay, I told you I know nothing about the case. But it's before the ZBA.
Yes.
So they asked for our opinion on what? On how the number should be calculated, or the accuracy of the number, or what we think the number should be? Because it seems to me that we've got the work that Jen did, the work that the assessor did.
I don't have the,
Why should we step in and say, we have yet another opinion?
the building inspector wrote a letter to the ZBA indicating that the ZBA had to issue a special permit and it was related to another section in the code. Wish I had the letter in front of me, but I don't. That section in the code that the building inspector's letter referred to specifically states that the planning board shall be the special permit granting authority. So before the ZBA hearing, when I saw that, I questioned it with the building inspector. And he said that, yes, that the proponent still has to go before the planning board under that section and get a special permit. But before doing that, the ZBA has to issue a special permit that states that this type of housing is permitted in a residential B district, because the reference in the building inspector's letter, the reference in the code is, it only states that the special permit shall be granted by the planning board. It only states that in the residential A district part of the code. The residential B district part of the code is silent relative to this type of housing.
I think the first line in the residential B use regulation is all uses allowed in residential A district. So that sends you to the residential A, and you look at paragraph B, I think, that says uses allowed by special permit. And that says there are 3 uses that mention mention housing for the elderly. One is the one we had the big discussion on because it requires ownership by a nonprofit. The second one is basically the same, but without ownership by the nonprofit, which is very confusing. And the third one is under a major residential development regulation with a special permit by the planning board. So there's also a clause in there that says something to the effect that the developer still has to go before other boards to get various permits, like conservation and Board of Health. And that one says including conservation, Board of Health, maybe one or two others, and planning board for site plan. So I love working with Mr. Bemis because he pays very close attention to the wording and I think raises some very good issues. His position, as I understand it, is that because that mentions specifically going to the planning board for the site plan, then it excludes going to the planning board for a major residential development special permit. I disagree with that because the first word of that is including. It doesn't say limited to. But, so what they want to do is not do a major residential development. They want to go with this 174-9H, which gets us into the count of the number of over 55 units.
Gets us or the town?
Gets the town, yeah, very good. Gets the town. But if that's the case, that count is clearly for the ZBA, I think, in reading the regulation, because it relates to their grant of a special permit. Long way of saying it, but you may be right. It may be something we don't even need to be looking at.
The first question was why are we responding to the building inspector?
Was that who sent us the letter?
Well-
Building inspector or the ZBA?
No, the building inspector.
Okay.
And the draft letter is addressed to the building inspector, and it references his email, which on February 29th, the building inspector sent an email to Hillary. Greetings, Hillary. At a recent ZBA meeting, a town resident raised a question regarding the accuracy of the planning board's over 55 calculation posted on the town planning department website. Could you please look at those numbers and confirm that they are accurate and report back to me? So he asked Hillary to verify the town planner's calculations. I suggested that when I discussed it with Hillary, I didn't think it was her place or her position to go ahead and verify those numbers, that it fell on us. And so that's why I looked at it, and I felt that because we were meeting tonight, that we could all look at it and then respond accordingly.
I don't remember three-family and apartment buildings, et cetera, being in the chart that she gave us in January.
This,
She gave us the chart again, her revised chart from 9/25. January 13th, Wednesday night, when we met at the library. And I don't remember those being there. Could be.
we didn't change this.
Okay.
I'm actually looking right now on the website. It's on there. It's got,
It's on
I
the
can read
website?
it,
No,
yeah.
fine, if it's on the website, that's all I need,
Well-
thank you.
yeah, actually exactly what's on this grid tonight is what's posted currently.
So the question is, do we agree with that count? Or if we don't, then what number do we think it should be?
Let me just make one correction. The remaining allowed is 11.46 as opposed to 11.6 in this. So I'm not sure why it's different in decimal points, but it's virtually the same. Let me put it that way.
It was explained to me why it went from 11.46 to 11.6, but I can't remember why.
Was it the addition of fiddleneck?
I don't remember.
Because that was,
Mr. Chairman, are we trying to come to a conclusion as to whether or not the website should be revised at this point?
Being asked by the building inspector if we agree with the numbers that,
Could you just read the bylaw one more time carefully?
the total cumulative number of units approved under this section by the zoning board of appeals since January 1998 shall at no time exceed 7% of the total number of one-family houses in Southborough at the beginning of the year in which the application is filed, based on the assessor's records, period. So if that was the end of the section, then you just count the number of one-family houses and that's it. The next sentence says, though, residences containing apartments shall be counted as one-family houses for the purpose of this subsection. So the way the town planner did this and the
I
building
see.
inspector,
okay.
a two-family or a three-family or apartments with over 3 units are all those residences, those houses that contain those apartments are counted as one single-family house.
I ask Mr. Stivers to address that? Sorry, my
Oh.
mic was off. Well, because he's the one who raised it at the ZBA meeting. That's how we ended up having this conversation in the first place. I'm just curious to hear, because I'm trying to understand what the interpretation
I'd
is.
just as soon read our own bylaw and interpret it. I mean, none of us are experts at this, so why add 15 non-experts? There's 5 of us who were elected to read and interpret, and they've asked the planning board for an opinion, and up until, I was leaning his way until you just read that last sentence.
That's basically what the building inspector was saying, that it seems that if you consider this last sentence, it has to be this way. It has to be calculated that way. Residences containing apartments shall be counted as one-family houses for the purpose of this subsection.
So are you saying, for instance, where it says 3-family, and it says 7, are you saying each of those 7 equate to a house with an apartment?
Yes. You picked a good example there, Phil, because that is the example that we used in the letter. The quantity of one-family, two-family, three-family, and apartment buildings was provided by the assessor. We used an example here. There are 7 three-family houses in town. The bylaw requires these to be counted as 7 one-family houses, not 21.
See, I wouldn't even have counted multifamily until I heard that reading. And that reading says it doesn't say single-family homes subdivided into 2 and 3 families should be counted as one, as I've had it defined to me before. It says residences with more than 1 unit shall be counted as a single family. So I'd go with it.
Anyone else?
You need a motion? Are you looking for a motion?
I guess
I think-
if there's any changes to be made to the letter,
Or
we
even
should,
to pass it as written, I think. I've had that thrown in my face more than once, that where was the vote of the planning board that this letter should be sent?
I'd like to make a motion that we not make any adjustments to what is posted on the website on the basis that I've not heard any reason to make an adjustment, and it seems like we're conforming with the current code.
Second.
well, I believe, did you say that the website said 11.46?
Sorry.
Did
Can
you
you
say the
repeat
website says 11.46?
So if I can just amend my motion that the website be updated to reflect the corrected numbers as presented by the building inspector in tonight's packet. Is that correct?
The numbers that are in our packet are numbers that were generated by the town planner.
So, Mr. Morris,
Let me start,
She
let me
I'm
did it
start.
in conjunction with the assessor.
I'm pretty sure that what's on the website currently posted was what came from the town planner. I think,
Right, but then it got changed.
after the town planner left.
No,
It got changed to
Yes.
this, but the website wasn't updated?
she didn't, this is as of January 5th. She was
Oh,
here
she's
until
still there.
January 15th. These are her numbers.
Okay.
So, so the website just hasn't been updated yet?
Correct.
Okay, so my motion then is that the website be updated with the corrected numbers,
And that this letter be sent to the building inspector?
and that this letter be sent to the building inspector. Agreed.
Second.
Motion's been made and seconded. Any discussion? All in favor?
Aye.
Aye, 5-0. Very good. I'll sign this letter. Oh, well, I'll put it on planning board letterhead and send it to the building inspector. Not tomorrow. It'll be Wednesday. Hillary's not going to be in tomorrow. Thank you for that. I think the only other item, was there any other items other than the reference in the agenda to talk about the Park Central waivers? Waiver requests?
Minutes.
Do we have minutes in our packet?
We did.
Through the interest of time,
Can we, I haven't,
Table
I'm
those?
gonna admit that I didn't read them.
So we'll move the minutes to our next meeting, which is on the
21st.
21st.
Now we'll get out of your way so you can start your next item.
have a good night, Kathy.
Thank you. For those watching, I'm leaving because I have recused myself from the Park Central discussion due to a brother-in-law being within a distance that some think is, could be impacted by the project.
Sorry, one other item before that. The planning board voted at the joint meeting last week on Fox Hill Drive and William Caleri Lane. Those who were part of that vote, we need to sign these Mylars. I'll put them on the table there. Did you want to sign them, Kathy?
Sure. Let's get it done with. Bring my-
Mimi Luttrell, 19 Oregon Road. I'm the chair of the Open Space Preservation Commission, but I'm speaking as an individual. I'm speaking in reference to the bylaw change for the over 55. I'm also a plaintiff in the lawsuit that was being referenced. I think some of what was said with regard to the dicta our attorney would disagree with. Our argument is that the,
Excuse me, when you say our attorney, you mean your attorney, not town council?
correct. Our position is that the community housing organization requirement in the bylaw is a limitation of use, not a regulation of ownership. So I would like to ask the board if our attorney wrote a letter explaining that and why this appeal is still ongoing, and it does make a difference. And I'm not an attorney, so I don't know what a dicta is, but if our attorney wrote a letter, would the board accept it?
I mean, if we received a letter from your attorney, would we accept the letter?
Yeah.
Only if it was submitted with intent, no. Sure, we'd accept the letter. Any piece of information that we can get to help guide us in our decision, sure, why not?
Okay. All right. Thank you.
Mrs. Bartolini, microphone, please.
I have a question. The case that we're referring to and that Mimi has identified herself as part of, is our board the one that's being sued?
No.
No. Okay, I have been told this week, as this finally came to my attention, that the case that was causing the dicta to have been released, that it was our decision that was being appealed.
That's not correct.
Whose decision is being appealed?
The Zoning Board of Appeals,
The Zoning Board of Appeals.
the over 55 is the special permit granting authority for the over 55 is the Zoning Board of Appeals.
Thank you. I think the only other item on the agenda, I put it on here in case anybody wanted to talk about it. Mr. Stein and I attended that continued hearing, is that right, Jesse?
I actually left for the waiver request, but I was present. I did ask about the feasibility study, but I don't think that's on tonight's agenda. I have a copy of it just as an FYI in case anybody wants to look at it, what was provided to me by Karen Finelli in terms of the feasibility study, but that is not what's on tonight's agenda for a discussion item.
So if anybody, if you saw the replay, then you'll know what we're talking about. But I wanted to put it on there because it was a little bit different than what we're even used to seeing, which was that it was on February 24th was the date of the continued hearing. And we learned at the meeting that a letter prepared by the proponent for Park Central dated February 24th was submitted and accepted by the ZBA, and that the ZBA discussed it, and in one case voted on one of the waivers. It didn't affect the waiver that they voted on. I think they voted on 2 waivers. There were 3 waivers. One, the planning board was the permit granting authority. I don't believe they voted on that. The second one, the ZBA was the permit granting authority, and they voted on that. And I believe they were within their authority to do that because it was their own special permit under their authority. And then the third was the Conservation Commission was the special permit granting authority. And I just wanted to bring that up, that that letter from the proponent was dated the same day as the hearing. To my knowledge, it was not made available to the public. It was not made available to the planning board, and I was told later that it was not made available to the Conservation Commission, nor was there any knowledge that it was going to be submitted that night. So I wanted to bring that up, and I'm sure it'll be a topic of future discussion. Does anybody want to make any comments relative to that? Mr. Jenks?
As I understand it, the waivers listed in this letter pertaining to planning board regulations were not acted upon.
I think you're right. I think that that may be, they may be gone over at the next continued hearing. Anything else?
Well, the other question I asked that night was what is meant by residual site plan review? And maybe you guys already know this, but you do know it. It's just for the public. It's parking, streets, landscaping, and trees. I didn't know that before that night, so I was glad to learn it. Exactly what it is we will be reviewing, and I think he said it was going to be sometime in April that we would, as far as time frame.
I think that's right, but let me correct you, it is not streets, it's common driveways.
Sorry, and of course I'm referring to the 40A condominium project, which is not streets, it's correct, the driveways.
But the letter submitted to the ZBA on February 24th included a request for a waiver of common driveways, the common driveway regulation.
So we're down to trees, landscaping, and parking.
I think if you, and I'm not sure if that letter ever made it to the website, but the letter from, the waiver request letter submitted to the ZBA, several pages. Do you have it, Phil?
I do.
How many pages? Contains
Four.
multiple waiver requests.
4.
And it's, again, it's on our agenda because it's a matter of great concern that there are additional waivers being requested beyond the conditions in the use variance and way beyond the 40B part of the project. Mr. Jenks?
This, among other things, is looking for a waiver of the total zoning code. Everything in the zoning code from section 174-1 through 174-28. It's looking for a waiver of a portion or one requirement of the common driveways. It says as a one-liner, section 174-10, site plan approval. So that says to me they've decided they want a waiver on the whole site plan approval. Some items specified under signs and under parking and loading regulations. And then the whole section on outdoor illumination. Some specifics under the 174-13, the landscaping, and then the whole lower impact development regulation, the whole water protection regulation, the whole stormwater and erosion control regulation. And then it goes into the conservation things, which they did vote to waive.
So this begs the question, is this asking for these waivers on the 40A and the 40B, or is it just the 40B?
Well, they don't have to ask on the 40B.
Right.
They are in charge of the 40B. They are asking, as it relates to this, the 40A.
So,
And they start this by saying, in connection with the pending Chapter 40B application for a comprehensive permit, and this is the important part, and so as to allow for integrated site development, and then in italics, as required by the board in its May 27th, 2015 notice of decision on a use variance. They've mixed the concepts because the 40B had nothing to do with the use variance. The use variance had nothing to do with the 40B. And they are combining these now at this point and talking about an integrated site development as required by the use variance.
so included in these waivers is site plan approval, landscaping, and parking.
Yeah.
So does that not contradict? I just want to make sure I'm understanding what's going on here. How does that not contradict what the ZBA chair told us at that meeting when I asked specifically what residual? If it does contradict it, then to me, we're back in the box of looking at special counsel. Correct?
Well, not necessarily. I think that we got a clear message that if we have questions on these items, we ought to be asking our town council for help with them. And if he decides that we need special counsel, then he'll make that call. I think that's the way the process works.
I think the final call is on the selectmen. You had pointed out in the code
It needs their approval, for sure.
that selectmen have to vote to grant permission to get special counsel. Well, the reason, again, it's on our agenda is because it's a, not just procedurally, that this document was submitted the same day as the hearing, without giving it to the public, without giving it to the boards who, in some cases, are the special permit granting authority. No ability to comment is just not the way to go. It's just one more procedural, in my opinion, one more procedural error and overreaching into other boards' authorities. And in this case, now it's the Conservation Commission. We can comment on that, but they're the ones that, it's in their court for that one. Anything else? Before we leave, we had already voted on these plans, so if we adjourn, we're still able to sign these Mylars for the selectmen.
Motion to adjourn.
Second?
Motion's been made and seconded. Any discussion? All in favor? Aye. 4-0. Thank you.